right, Brandon, are you ready?
Yep.
There he is.
Yep, see, told you.
And he's ready. All right. We'd like to welcome back to the podcast, Mr. Brandon Rains.
Thanks for having me.
Third time here.
Yes, that's true. I forgot about the second time.
So Brandon is an experienced estate planning and business planning attorney practicing in the Denver Metro and Fort Collins areas of Colorado. His practice is values-centered, client-focused, and relationship-based. Yep. Thank you for coming again.
Thanks for letting me on again.
You can come anytime.
Okay,
anytime. All right, so since we've already asked you the first job question, we're going to ask you, what is your pet peeve?
Yeah, so I'm glad I actually saw that question when I looked at your I was like, oh dear, what is my pet peeve?
You're not supposed to look.
Yeah. Pet peeve. I would say probably the thing that came to my mind is complete irrationality. That sounds really judgmental, and that probably doesn't sound very nice, but you asked the question. So
give us an example.
So, oh gosh. I'm not very good at examples, but I think for me what it kind of comes down to is I can do a pretty good job at understanding where people come from, right? If they walk me through the process of making a decision, I was like, okay, like I don't necessarily agree, but I can see where you get there, but things that just make no sense in any way, shape, or form. It's probably not quite a pet peeve, but that's the best answer I can give, right? There needs to be some
basis.
A to B to C, not, if you're trying to get to D, A plus B plus C equals D, rather than like A and then F. Like that. I struggle with that a little bit.
Well, and
it's got to make some sense. If it doesn't make any sense, then I struggle with that.
Well, and it's really interesting because people make decisions based on their life experiences, right? Or like what they were taught. And like, there's just so many things that come into decision making that it's hard sometimes to be like, how did A plus F equal Z?
Yeah.
But to them, it makes sense, right?
Lots of times. And so that's a good thing about being an attorney is it gives me an excuse to be nosy and not feel bad about it.
It's a good thing about being a CPA. I ask a lot of questions. I'm like, tell me your life story. Tell me what's happening with this thing that you probably don't want to talk about, but you should probably tell me anyway so I understand why.
Totally. Exactly. And so if it is like A plus F gets us to D, I'm like, okay, help me figure this out. So I dive in pretty deep, and if it still makes no sense, then I just don't know what to do with it.
Okay, we're just gonna put that one
flesh
away.
that out a little. We flesh it out a little bit. What is F? What does that look like? And then if it still just makes no sense, then I just have to chalk it up and say I'm just not going to be able to understand this.
Okay, so how about we replace F with B? How does that feel? How does that feel to you?
That's right. Yep.
Okay.
But but emotional decision making is okay too, right? I'm not trying to say just needs to make sense, right? If F is an emotional component, that's okay, right? That's a valid data point. It's just has to connect somehow.
I love that. We went totally down that rabbit hole of pet peeves. Yeah. So last time you were here, we kind of just did some overview of how you work with clients and, kind of what estate planning is. So I'm going to ask some more technical questions today because I need to know more about estate planning. And then I'm sure our audience does because people say estate planning and they're like, what does that really mean?
Sure.
So what are the components of a robust estate plan?
Great question. So defining terms first. So what is an estate plan? Right? Sometimes people don't think to ask that, but then when we dive in, they'll ask questions that kind of show that they didn't quite grasp what an estate plan is. Right?
Yeah.
So an estate plan is a legal way to protect and pass on assets.
Okay.
Right. So legal, financial assets. There's two main parts of an estate plan. There's what I call incapacity planning, which is when you're alive, but mentally unable to make decisions for yourself. And then there's what I call passing away planning or death planning.
Okay.
So incapacity planning, there's 4 main documents and they all do different things. Well, 4 legal documents, I should say. There's financial power of attorney, which says if you're, again, alive, but mentally unable to make financial decisions for yourself, who can make those decisions for you and what kind of decisions can they make? So some examples of financial decisions would be paying your mortgage, paying your utilities, managing your bank account or your personal belongings, or selling your house if you needed to, opening your mail that, without breaking federal laws, right? Stuff like that. That's kind of under what I call a financial power of attorney. The official term is a general durable power of attorney, but that doesn't mean anything. And so I just like financial power of attorney. You have medical power of attorney, which is if you're alive but mentally unable to make medical decisions for yourself, who can make those decisions and what kind of decisions can they make? Whether that's treatment, hospice, psychotherapy, pain management, surgery, just general treatment stuff, right? You have a living will, which is if you're in a terminal condition or a persistent vegetative state, 0% chance of recovery. So incurable, irreversible, you're incapacitated, you can't express your wishes anymore. What do you want to have happen with life-sustaining procedures and artificial nutrition and hydration? Do you want them to be stopped? Do you want them to be stopped after X number of days to kind of give family time to come in and say their goodbyes and get their closure? Or do you want to be continued indefinitely? So you're pre-expressing wishes. And then the fourth document is a HIPAA waiver. HIPAA's federal privacy law, or medical privacy law, I should say. And the HIPAA waiver, HIPAA authorization, call it whatever you want. It's just a list of people the doctors can talk to. There's no decision-making authority with that at all. It's just, if they say, hey, what's going on with Jamie, they can answer those questions or not, right? Simple example of that is whenever you go to the dentist or wherever, you sign like a medical release form. It's exactly that. It's just writ large, not limited to just the dental office, right? It's to any hospital that you present that document to, right? So that's incapacity planning. Any questions about it?
No.
Okay. Clear as mud. Awesome.
No. I think that's helpful because we say estate planning all the time, and it's like, what does that mean?
Yeah. So maybe an even broader definition of estate plan, right, is what is an estate, right? So an estate is everything that is in your name. You are the legal owner of it when you die. So it's a plan for your assets when you die, right? And so you have the incapacity stuff and you have the death stuff, which is wills versus trusts, right? They do different things. They accomplish different goals. The main differences between a will and a trust and how they interact with your assets after you pass away is a pure will goes through probate. Probate is a court-supervised, not court-administered, but court-supervised method of paying off your debts and distributing your assets out to the people that your will says you want to receive your assets. Probate's a public process. Reasonably public process. In Colorado, has one of the best probate systems in the country. So great place to live, great place to die, turns out.
Good to know.
Yeah, so don't move.
To self-die here.
Yeah, totally. And then a pure will distributes out all of your assets in one lump sum distribution.
I think just all at once.
So at the very end of probate process, after all your debts have been paid and all that stuff, basically it's oversimplifying it, but if you just sold everything, turned it into cash, and you would write a check for everyone's portion, and they would just take it to the bank and deposit, and you're done.
Okay. Right?
So that's a will. With a trust, if you do it right, and I won't bore you with details unless you really want to go into the details. Okay, great. So with a trust, it can avoid probate. Avoiding probate in Colorado is, again, not a big deal.
And probably not a huge goal a lot of the time.
Not really. I mean, sometimes people come in and it's a big goal for them, but it doesn't really need to be. For trust as a probate avoidance technique.
In Colorado.
It's not, in Colorado, not that big of a deal. Now, if you own real estate outside of Colorado, big deal. There are other benefits that a trust has over a will. Mainly being, instead of a one-time lump sum distribution, a trust can spread out distributions over time. So you can say... You can decide when and who and where. You can decide the when and the how of who gets your assets, right? When they turn a certain age, which is not something I'm personally, professionally big fan of age-based distributions. Or you could say, hey, we want to help pay for your education. Or when you get married, here's we'll pay for that. Or...
We'll sell this asset and give you your money.
Or whatever. Yeah. Or, we want to avoid entitlement or hard work, or I've seen some really fun, creative things with a trust that says that I call them maturity-based distributions.
That makes sense.
Hey, you're making a good choice. will either reward you for that, or you have a worthwhile, productive goal, and we'll use the trust to help you reach that goal. Home ownership, entrepreneurship, stuff like that are kind of a little bit more based on positive life decisions.
Cool.
And a trust can do that, and a pure will can't.
So if I had a nonprofit, for instance, like if I created a nonprofit, there might be something in the trust that says, hey, if you create a nonprofit, we'll be 50% of your donors if you have another donor or whatever.
Yeah, you could do that. Or if you don't start your own nonprofit, it's if you wanted to contribute, right? So some things I see people do is, like for education, like a scholarship matching program. So for 50 cents on the dollar, or $1 to $1, whatever they want to do, academic scholarship or any type of scholarship. But I've seen that kind of be divided up, right? It's like, oh, only academic scholarship, and other people are like any type of scholarship. So scholarship matching program, I've seen a wage matching program, or a philanthropy matching program, right? So even if you don't start your own nonprofit, it's if you want to give to a nonprofit that you're passionate about, we'll match that donation at a certain percentage, whatever the people who are creating the trust decide they want to do.
So that's how we also, through the trust, we pass down those values. So you do value-based planning.
Yep.
And if we create a trust that has the same values as the people passing it down, like maybe charitable contribution, like charitable giving is one of their big values, then you create a trust that helps them do that value.
Yep, pretty much.
That feeds into that value.
Yep, and that's one way to kind of address this values-based planning is financial distributions. There are a lot of other ways of tying in this values-based conversation. So simple example is actually naming the trust. It's a really easy way to, and I think I talked about this in our last podcast.
I'm not sure you did. I don't think you've heard about naming.
Okay, we'll do it again.
Let's talk about it again.
We'll do it again. So normally a trust is like an entity. It can only control the property that it owns. Right. So I can't sell your business, or I can't sell your house because I don't own it. So since the trust is an entity, it needs to have a name. So the default name, so using my family as an example, would be the Brandon and Emily Rains Trust, dated, blah, blah, whatever, blah, blah, blah. Which doesn't mean a whole lot, right? You're just attaching it to your name. No big deal. Perfectly fine. It's a nice default, but it doesn't mean anything. And so one of the conversations that I have with my clients is coming up with a name that has meaning to them as a way to express value. So for our family, being a religious faith-based family, ours is the Rains Family Eternal Priorities Trust. And there are reasons why we chose Rains Family rather than not eternal and priorities and eternal priorities, right? And so coming up with a name that it kind of identifies those values and expresses that, but also taking the time to kind of write out why you've named it that way, right? So not just, so at least for my clients, because this is my reference point, they open up their trust, and their trust has a title page. So the title page for us is the Rains Family Eternal Priorities Trust. But then the very next page is our write-up explaining why we named it that way, and why it has meaning to us, and how we would like that to guide our children to prioritize things of an eternal nature and eternal value rather than the next passing fad, right? And so for us, it's that. I've seen...
Don't buy Teslas.
Don't buy Teslas? As
no
the name
Bitcoin.
Of the trust could.
I was just thinking.
I was like
could. What is the latest fad that we don't want to put?
Oh, the fad stuff?
Yeah.
Gotcha. Yeah. So I think Teslas are awesome.
Maybe no Bitcoin.
Yeah, probably. Yeah, maybe not. But I've seen some really fun and interesting stuff. So I've seen Legacy of Love Trust, the Discovered Trust. I've seen the Nest Egg Trust. I see a lot of legacy, that word thrown in there.
I have
Beacon
a client
Legacy
who
Trust.
named his after his favorite bike trail.
Okay, there you go. Right. So yeah, totally. Right.
Yeah.
And you could definitely, I mean, the next step of what I would say is, okay, write up why you care about biking so much, right? Because that's part of his life story. That's part of his value system. Right. And so I've seen Family Inside Jokes be the name of the trust.
I like it.
I won't tell you the joke. It's not funny. I'll tell you after. It's not funny. And you can come on later as like an addendum and explain to people that it's not funny. but that's okay. Like even after they explain
because it doesn't matter.
It doesn't matter because it's meaningful.
To them.
It's totally funny to them. It's like the ultimate dad joke.
Yeah.
Totally. But because it's funny to them. And when they see that, it will have meaning to them and it'll help them remember mom and dad. And that's all that matters.
Yeah.
You know,
that's
my
simple.
opinion doesn't matter, right? Whether or not it's funny or not. And so it's just stuff like that. Or, you know, kind of an example that I give too is helping children understand why mom and dad did the things that they did.
Right.
Because it's one of the biggest issues of estate planning is actually the estate administration side of things. So after my clients are gone, the trust is truly meaningful and truly important. A lot of people talk about how an estate plan is like the last letter from parents to children. Mm-hmm. Legal passing on of financial assets. That's seriously the last letter that kids get from their parents. And so it's I've heard stories. I mean, I haven't seen this with my clients yet, fortunately, but I've heard a lot of attorneys, they'll have children and grandchildren come up to them and say, did mom and dad or grandma and grandpa write about me in their trust? Did they say something about me in there? Mm-hmm. Like wanting that emotional closure that can come with being remembered in this all important document. But it's just like, this is how the who gets what, when, and how, right? And the example that lots of times I give people is if you have a couple, it doesn't matter how much money they have, $500,000, million, 10 million. They have two kids. One's a doctor and one's a drug addict. Very different life situations, but there are estate planning reasons, legal transfer of financial assets reasons to treat them exactly 100% the same. Like I wouldn't blink an eye. And I don't think any other estate planning attorney would blink an eye at this strategy that I have in my mind that I'm not trying to bore you with details with, but it's maximizing asset protection, right? 100% valid reasons to treat them exactly the same. But how do you think the doctor will feel when they read through the trust after mom and dad are gone and they find out that they're being treated exactly the same as their drug addict sibling? Without any explanation. No, like this is how you're getting it. Yeah, it's did mom and dad not trust me? Surely they trust me more than my ne'er-do-well sibling, but apparently not. And so you get
ne'er-do-well.
Right?
I love that I need to use that more often.
Yeah, I'm glad that you finally. No one else calls me out on that. Thank you. I think. But it can cause self-confidence issues, self-image issues. It can cause bitterness towards mom and dad, which they're gone, so they're going to take it out on their sibling lots of times, right? And so that's going to potentially destroy a relationship that, if there was one even anymore, right? Because you have this high achieving and struggling sibling dynamic,
or whoever's executing the
or
trust.
whatever, right? Yeah, and then they have to be told no by the trustee, depending on how this has been, structured and stuff like that. It just causes a lot of emotional issues, potentially financial. So take a step back. So there's studies that have shown that have been over since the 1980s. They've asked descendants, has your inheritance been a blessing or a burden in your life? And about 80% of them say that it's been a burden. Emotional, physical, financial, relational.
Isn't that crazy?
Emotional and mental burden, right? I repeated one of those, but that's okay.
It's like winning the lottery.
Totally. Well, whatever percentage of lottery winners declare bankruptcy, right? It's not
a huge percentage.
Yeah, it's a burden in
I
disguise.
don't know the actual statistic, but it's a lot.
Ginormous. And so just in this little example, it kind of highlights that, right? And then that the drug addict sibling they're going to come out of that of, okay, well, now I know mom and dad didn't trust me, but they might even start asking questions whether or not mom and dad loved them, right? Because there wasn't an explanation why. Now you take value-centered planning, purposeful planning, and you inject a conversation about the why, right? So a normal estate plan, who gets what, when and how. You throw in a why, right? And so you put in the trust, or you put in a letter, however you decide to do it. They're talking to their doctor or child, and they're like, okay, we do love you, we do trust you, but they say you're in a highly litigated, highly sued profession as a doctor. We have essentially designed this trust in such a way that if you ever are sued, declare bankruptcy, get divorced, any of these outside influences coming in and trying to get your inheritance, we've designed it in such a way that they can't get to that inheritance. And so no matter what happens, you will always have a safety net to fall back on. Even if you lose everything else, you will always have what we've given you. And all of those issues are immediately gone.
Right.
Just because simply they understand why mom and dad are doing
that
what they
they
did.
thought it through. And
That they thought it through and there was a reasoning, right? A plus B plus C plus D, right?
Right.
And so, and they can grab on and it's like, okay, good. Right. And that drug addict sibling, child, we do love you. You struggled. We know you struggled. We've designed this in such a way to help protect you. We're going to, pay for treatment if that's ever needed. But we've designed it in such a way to protect you now. And when you start to get over this, because we know you will, it'll be there to help you take those positive steps forward. And next thing you know, this trust, instead of exacerbating pre-existing issues, could actually become or within themselves, right? Especially with this drug addict sibling. It can actually become a light in dark places when they read written down that they'll never be able to forget. They can always go back and read, no matter how tough life gets, is mom and dad loved me.
Yeah.
And they had confidence in me that I can get over that. And that could be that light in dark places when they most need it.
Yeah.
So yeah, it's fun and exhilarating,
So cool.
just possible stuff that's beyond the normal. This is how much you're getting, and this is when you're getting a conversation, right? It's much more than that.
That's really cool. All right. Where am I?
You're just stunned.
I know. Well, no, it was just so good. And I need to ask a next question that's good. Okay. So we talk about trusts, and there's different types of trusts.
Yep.
So I'm going to just continue to ask technical questions.
Okay.
Can you just give us a simple overview of each type of trust?
How much time do you have?
Just quick. Just do it quickly.
Okay. So the two main ones that people need to worry about is a revocable living trust. When we say trusts, that's the vast majority. When people say, hey, do you have a will or a trust? They say a trust, that's what they're talking about, right?
So revocable. Revocable
living trust. Revocable meaning you can revoke it, modify it, amend it, change it. As long as you're alive and as long as you're sane, you can change it. Living means it becomes income. You've created it while you're living. Okay. The other main trust is called a testamentary trust. That is after you've passed away, you've created a will, and in the will language, you have a trust in it. And so it's a trust that's created when you die, as opposed to living. Okay. So revocable living trust, while you're alive, you sign it, it exists, just springs into life. Testamentary is created by the will after you die.
So what happens to a living revocable trust when you die?
It becomes irrevocable, which means you can't revoke it, modify it, amend it, and stuff like that. So after you die, there's no difference between a testamentary trust and a revocable living trust after you die. They function exactly the same. The real difference is, when do they get created? That's the main difference.
And how are they administered? On the living side.
It's not so much how they're administered, it's just how they're created, right? Okay. And so with the revocable living trust, you get your document pages and stuff, you sign them, it exists. Testamentary trust is created through the probate process of the will. And when probate ends, the trust is kind of
begins.
Essentially.
It's the vehicle.
Yeah, basically, right?
The vehicle to
yep. So the
dole
will,
out the will.
So the will makes the testamentary trust receive everything, and it goes into that testamentary trust. It's irrevocable already because you're gone. Right. Okay.
Can't be changed.
Yep. So at that point, they're both irrevocable trusts, and so they function. They're administered once they both exist and are created. They are administered exactly the same
by their trustee under whatever the documents are.
Yep. Now there are, I don't know, probably 24, maybe even 3 dozen other types of trusts. Most of the time, that's estate tax planning or income tax planning. So most of those, the ones that are really dealing with estate tax planning, right now the estate tax exemption is $22.8 million per couple. So it's 11.4 per individual, and indexed to inflation. So each year it's going up, right? Depending on how much inflation there was. Most people don't have those concerns, right? Darn.
No.
I think there's less than 2,000 families that have to worry about it in the United States or something like that. And so those just don't exist all that much anymore, right? There are some that deal with income tax planning. That could be when you're selling a business, right? Instead of it's kind of like a will versus trust scenario. I'm oversimplifying, but instead of getting your $5 million from selling your business all at once, you get $1 million a year for 5 years to spread out that income tax liability. directly. And there are some trusts that do that and stuff like that.
Well, that's interesting.
Yeah.
I had some questions about that for me, actually. So with the Tax Cuts and Jobs Act, everybody's looking for more itemized deductions. And so a lot of the conversations for people who are charitable are they charitable donor funds?
So there's donor advised funds.
That's
there's
the donor
charitable
advised,
remainder
and
trusts.
then charitable remainder trusts, where we put all that charitable stuff into one vehicle, take the entire deduction in 1 year, and then the money is doled out as they see.
Yeah.
So are you doing a lot more of those now with the Tax Cuts and Jobs Act?
I see a lot of a charitable remainder trust is different from a donor advised fund, and again, oversimplifying in two main ways. One, it's estate tax planning. You put, just using round numbers, $1 million into a charitable remainder trust. That is out of your estate. And it's out of your estate, which means you don't own it, which means it doesn't count to that estate tax exemption. So if you're worth $24 million or $23.5 million, you put $1 million in charitable remainder trust, your estate is now less than the exemption, right? So that's charitable remainder trust is estate tax planning. But what it also does is you put into the charitable remainder trust, and there's a term of years, and it can spit out income back to you during the term of years. And at the end of the term of the trust, whatever's left is given to the charities the designated ultimate beneficiary of that, right? Whether that's the Dumb Friends League, a specific charity, or you can actually put it into a donor advice fund. Right. So you can do it that way. You can have a little bit of a mix and match there, which is kind of fun. Donor advice fund, it gets it out of your, I think it actually gets it out of your estate. Off the top of my head, I'm blanking. But it doesn't, I'm pretty sure it does. It makes sense for it too. But it doesn't give you a stream of income. Right. So it's in this charitable vehicle. You get that deduction, but you're not distributing out to those charities that year, but it counts as a charitable deduction, but you've put it into the donor advice fund.
So it's funny because I have people ask me about donor advice funds, and I'm like, you only gave $200 the last year. So those really only work for people who one of their priorities is, or one of their values is charitable giving. And I think the other thing too that makes a lot of sense is when they want to get their family involved in that charitable giving, right? If it's really just spouses who are just content giving that, whether that's $200 a year or $200,000 a year or whatever that looks like, to a specific charity, they're going to do that regardless.
That's fine, right? What I see when people are really engaged with the donor advice fund is when they say, we really want to get our children involved in the decision-making process, and they want to kind of accelerate that charitable deduction. So there's a little bit of tax planning there too. So they'll just put it in to the donor advice fund, and they name their children as one of the advisors on the donor advice fund. And they're like, we would want them to still be managing or advising that donor advice fund after we're gone. And that's the way to do that, because you can name kind of successor advisors. And so your children, so for it's just our spouse, us and our spouse, but we want our kids to kind of take this over, and there'll still be money left over. So that's really that's kind of my experience with donor advice funds. If you're just a one-time thing, you're perfectly fine with writing that check. You can keep on writing that check. You can do a donor advice fund and just put it all in. And then just have that corpus, that principle.
And if this is a value for you, and like maybe you come into a large chunk of money, like you get a severance package or whatever in 1 year, and you end up with like double salary, and it's a thing, that's a good time to do some tax planning around, if this is one of your values, maybe we put that, into a charitable advice fund, donor advice fund for now, just to kind of try to get some of that income off the tax bill.
Get some income tax planning.
Get some tax planning on that, because you're going to turn around eventually and dole that money out over the next 5 years or whatever.
Totally. And that's one of the great things about this. So there's kind of two parts of values-centered planning or purposeful planning. One is expressing your values, which can be naming your trust. The other part is, how do you get your children engaged with those values?
Right.
And that's the great thing about a donor advice fund, right? It's one thing to say, hey, we care about philanthropy, but if they're not engaging with it and living it in their own lives, there might be a gap there that's not bridged of, hey, mom and dad cared about this, but I don't care about this, right? But if you get them engaged and helping them be part of that process of deciding, what charities are we going to be giving to this year? How much?
What's important to us?
What's important to us, right? And helping them do that research and create a little presentation to the family and helping make those decisions. And then go back and maybe they're the ones delivering that check or saying, hey, we should give of our time also. And giving of their time and their money, and then maybe asking those charities that they've given to come back and say, this is what we've done with this money, or this is the benefit. And then the kids are involved in the decision-making process. They're involved in the giving, and they also can see the benefit from it. And that can really help them because they're engaging with those values, incorporating and internalizing those values becomes theirs as well.
I love it. So we're all over the place.
I feel like I'm talking a lot.
I know.
Is this a good thing? Or
This is awesome.
Okay. Versus you're much more talkative than this normally, Jamie.
I know. I'm trying, but you're doing a great job. So
you're just letting an attorney talk about themselves.
I know. I love it. It's fun.
It's
and well, the good thing is that this is all stuff I touch sometimes, but I don't have, full disclosure, I don't have a full understanding of how this works because I haven't been through the process.
Sure.
And I don't see it that often.
Sure.
Right. And I don't administer it or create documents or do the thing. So it's actually really nice to have you kind of explain how some of this stuff works because then I can also help clients understand their needs.
Sure. Yep.
Right, around this
Totally.
stuff. So what are some of the common deficiencies you see in estate plans?
Age. Number one is age. The average age in an estate plan in the United States is 19 and a half years.
It's 19 and a half years old and it hasn't been updated. Wow.
Nope. So the average age. So, where were we 20 years ago? Where are our kids going to be in 20 years? You know what I mean? That's really what we're looking at. So age, kind of touching on age. So building off of that is, there new assets have been created in the last 20 years. Digital assets of Facebook and LinkedIn and usernames and passwords and stuff like that.
Websites and brands and all the things.
Photo albums up in the cloud and Etsy and Pinterest and all that fun stuff. Those didn't exist. And there has to be language in there dealing with digital assets because that's actually part of your estate.
Yeah.
And federal privacy laws and the private service providers, Facebook and stuff like that, they don't have to communicate, talk with, work with, collaborate with any of your normal personal representative or your trustee if there's not language in there, right? Saying they have the authority to deal with digital assets. And even then it's kind of murky. We're trying to grapple and figure out the best way to deal with, because if you have, I think it's the average American has like 150 digital assets. So like e-banking, email, and
how do we
gets up there really, really fast. That's 150 contracts. Terms and conditions is a contract.
Not to mention usernames and passwords.
Not to mention, right? And so really what we're trying to grasp with is, one, to be perfectly honest, because we're paid to be paranoid, but we're also paranoid, is how do we protect our tushes as attorneys and malpractice?
Yeah.
Of what do we do with helping to facilitate products and services that can help integrate integrate's a fair word. Integrate dealing with all these 150 contract relationships that clients have.
Wow.
How do you bridge that gap? And there are companies that are kind of starting up and saying, or have been around for maybe 5 years, that say, hey, we have the secret sauce or whatever that is to be able to help that, to bridge that gap post-death so that the personal representative or the executor or the trustee has the ability to come in here and do what you want to do. Do what you want to have happen. Do you want your Facebook shut down? Do you want it to be memorialized? Do you want this and that and the other, right? How do you deal with that? And so that's an issue with age.
That's huge.
Just see missing language that really has to be in there. And it's not just digital asset stuff. There's a lot of stuff that is just, the laws become more sophisticated, not just our practice, but the laws have become more sophisticated, right? The codes are breeding like rabbits.
They need
right?
to stop doing that.
And so, and it just creates more red tape and plans
just more complexity.
Just plans that are 10, 20 years old just aren't keeping up with that. Right.
Right. And they're
so much has changed.
Tax inefficient.
Yeah.
I mean, on my end, I'd be like, this is completely tax inefficient because the laws have changed twice since then.
Yeah, totally. I mean, there's so many. I mean, I've had an interesting run of clients this year where I was like, look, your estate plan's 10 years old. You have really more advanced estate tax planning than you need to. Let's simplify this because we don't need to worry about it. Because they were planning from when the estate tax exemption was $2 million rather than $22 million. I mean, you just had to own a house and have a life insurance policy to have estate tax planning. Wow. 10, 20 years ago. So a lot of it comes around age. I would say age, lack of sophistication, very transactional, right? Of who gets what, when, and how.
But no why.
Yeah, legal protection, legal passing on of assets, of deficiencies. Probably another big one that I see is lack of. Let's a little bit of a soapbox here, but lack of contingency planning. So a lot of what estate planning, what I've seen, a lot of estate plans have, is just a plan A, planning for what life looks like for your family today. Now, my mind comes back to, okay, well, what happens if? Let's pick on you, Jamie. Let's say you and your husband die 10 years from now. Your kids are adults, right? Or pretty close.
19, yeah.
Yeah, 21, 19. So they're adults, right? So what happens if a year after both of you are gone, one of them gets in a car accident and they need to be on government aid for the rest of their life, whether that's SSI or SSDI or Medicaid or whatever. And you've designed this beautiful trust and it disqualifies them from government aid. We can't fix that.
It's too late.
Unless you put in language that it's what I call a standby special needs trust. What that means is if something like that happens, we have language in the trust that's standing by that says that their inheritance can be turned into a special needs trust. And what a special needs trust is designed to do is allow people to receive the benefit of their trust or their inheritance in such a way that it doesn't disqualify them from government aid. And so that's a contingency plan, right? That you hope you never need. But if you do ever need it, you're grateful that you have it.
We can't predict the future.
Can't predict
if we don't have a plan B.
Exactly.
Or C or D.
Yep. And so that's one that I always put in my plans. Another one is what I call like a court replacement option. So if there's any type of dispute, large or small, about what a trust says or what it's supposed to do, or is the trustee stealing from the trust or whatever, you have to go to a judge normally. Judges are great. Judges are awesome.
It just takes forever to do that.
It's inefficient. It's expensive because multiple attorneys, and lots of times it's public. And so there's other language. It's called a trust protector that is comes in before a judge, and they can handle those disputes privately, more efficiently, and more cost effectively.
It's like an arbitration clause.
Essentially.
Kind of.
Essentially. Oversimplifying as usual, but basically.
Well, yeah. But so that helps. I think people who have ever seen an arbitration clause that basically says we're going to try to make sure we can
do it privately.
We can make this a private conversation, or, we can resolve this privately before we take it somewhere else.
Yep, exactly. Yep.
So,
and another contingency plan that, these are ones that, and I'm not trying to be too salesy, but these are the ones that I put in all of my stuff.
What's important?
So another one is, again, picking on you.
Sorry. Pick on me all the time. That's fine.
Okay. So let's say something happens to you in a year, right? And you pass away. Husband gets remarried. How do we two things? How do we protect your marital assets from the new spouse, right? And how do we protect your mutual children from being disinherited, right? Because a normal estate plan,
it's a huge one.
The surviving spouse, at least what I normally see, the surviving spouse can change the estate plan after the deceased spouse, after the other spouse has passed away. So they can either purposefully or accidentally be manipulated or make that proactive decision of changing everything. And so children, there's the possibility and the risk there that they might be disinherited in favor of something or someone else, right? Or if the surviving spouse gets remarried and there's a new spouse, they spend all of it, of your marital assets, right? And so creating a specific type of sub-trust, right? So you have your main revocable living trust, right? When one of you passes away, it creates a special kind of trust that protects children from disinheritance and remarriage.
So it just creates, from that revocable trust, it kind of creates a mini irrevocable trust, kind of. Does that make sense?
Yeah. So yep. So it
like
makes
in my
it
mind.
Exactly. No, it's
like
irrevocable.
There's like two little irrevocables if one person dies and the other doesn't. So if you both don't go down in a fiery crash,
which is what
on the way back
which
from
is what
Mexico,
happens.
then
it happens most of the time, right? Most couples don't die at the same time.
Right.
And so there is the possibility of remarriage and changing of the estate plan, right? So when the first spouse passes away, that estate plan is set in stone. And the surviving spouse can't change it. So the kids, that the money will go to kids when both of you are gone. It's not going to be diverted to someplace else, right? And if he tries to replace you with some person who's not as cool as you,
well, that's like impossible. So
totally. You don't have to worry about him, giving all of that money to that person, right? So there are some restrictions kind of put in place and stuff.
That's really cool.
So contingency planning. So
I'm trying to see what we haven't answered yet. So because we have a lot of business owner listeners, and we are also business owners.
Yeah.
How do businesses fit into a estate plan?
So I would just kind of say like a Venn diagram in a lot of ways, right?
Yeah,
There's a lot of
totally.
overlap,
like
right?
overlapping.
Yeah. So if you want a business as part of your estate, I mean, that's a simple answer. Remember, because an estate is what assets you own that's in your name when you die.
Yeah.
Our businesses would be in our estate. So there needs to be some type of plan. Now, there's a bunch of different ways that you can plan for that. You can have an operating agreement if it's an LLC, right? So an operating agreement is like the constitution for your company, right? And you can have a buy-sell agreement, or you can not have anything, right?
So let's say I have a partner.
Okay. Buy-sell agreements are an easy way to do it.
Okay.
So what a buy-sell agreement says is if you die, become disabled, or you become divorced, well, a good one. And you can add in a couple other things, right? Is if one of those triggering events happen, it's providing for an automatic buyout of that person's share of the business, right? So if you have two partners, the business is worth $2 million. An easy way to what we call fund a buy-sell agreement is using life insurance.
Yep. It's
right?
the most common way we do that.
Yeah, most common. And so basically what happens is if partner one dies, that life insurance pays out, right? It eventually will go to the deceased partner's family and for $1 million for his half of the business. And then partner B, they own all of the business, right? So the family is paid for it. That's the main benefit of a buy-sell agreement, is it really does buy out someone's practice.
Yeah.
Right?
So we have to fund buy-sell agreements, though. We can't just create a buy-sell agreement and not really fund it. Otherwise,
well, I would say all buy-sells are automatically funded. It's a question of whether or not you want it to be self-funded.
Yes.
Right. Because most people don't have enough cash lying around to buy out.
Right.
Right. And that just causes a whole bunch of problems.
Right.
If you don't have a buy-sell or some type of language in there that deals with what happens to the practice, it becomes really problematic. So example that I have from earlier this year, it was a potential client. It wasn't a client of mine beforehand, but her husband was a dentist and he died suddenly and he didn't have anything. He didn't have a buy-sell or anything like that. So I talked to her on the phone and she was like, basically, I just remember this one time. She was like, I'm basically at the dentist at her deceased husband's dental practice, working the business, trying to keep the value of the business up so that she can sell it.
Because she ended up with the business.
Because there wasn't a buy-sell. And a buy-sell, it's automatic, right?
Upon
you passed away, the life insurance proceeds pay out. It's done, right? You have an invested person who's going to be coming in and working the business. Whereas she has to maintain the value of the business over the course of months until they can identify and finalize the sale of the business to somebody else, which normally isn't very successful. I'm not saying it goes from a lot to nothing, but you're probably going to be taking out some type of a pay cut from the purchase of the business because there's going to be lost value.
Because of the factors. And we can talk about business buying later at another time. But so it's very interesting because like most people's spouses wouldn't know how to come in and run a business,
Mhm.
like unless they've already been involved in that business somehow.
Yeah.
Like my husband would not know what to do with my CPA firm. He'd
Sure.
just probably send emails to all the people he can identify and be like, she's gone, sorry.
Yeah.
You know, like they
Mhm.
wouldn't know what to do.
Yeah. And there's a couple ways to go about that. Is, like I said, one's a buy sell.
Mm-hmm.
So for me, for example, what I have
Mm-hmm.
is I have an agreement with an attorney friend of mine
Mm-hmm.
who we have a close enough overlap of philosophy and approach and stuff like that. He's actually named as like my business executor or my business trustee.
Mm-hmm.
And he just needs access to my computer. My wife knows who it is. She'd give it to him and tell him how to log in.
Mm-hmm.
And he essentially becomes the trustee of that portion of the trust that owns the business, right? And so
Mhm.
he can. So there's not a buy sell, because that was like 2 or 3 years ago, and attorney firms don't have a lot of value,
In the
like
beginning.
actual financial value, especially at the beginning, right?
Yeah.
And so I was like, just taking, he's agreed to, pay a certain percentage of ongoing business to my family, right? So that's kind of how he's paying for it or whatever. And so, but you can name a power of attorney. You should
Mhm.
name a power of attorney for your business, because if you're incapacitated and you
Mhm.
can't work your business,
Mhm.
that's potentially even worse than you passing away
Mhm.
and not having a plan for your business. So power of attorney to deal with the business, and that can be different from the power of attorney for everything else.
Mhm.
And then having a plan in place for what's to happen for your business after you pass away. And that can be through normal estate planning documents or through a buy sell or through the operating agreement, right? So you can say in the operating agreement, if someone passes away, this is
Mhm.
how, the other partners have right of first refusal or for the first right to buy, to practice and pay fair market value for that.
Okay. So funny. We've hit pretty much all these. Let's see where are we.
I'll buy you some time. So
Okay.
I think that your business question kind of touches on something that is worth mentioning. Is it's a little saying that I have. It's different assets behave differently in different situations.
Yes.
Right.
That's
And
absolutely true.
so your house, when you die, behaves very differently from your life insurance policies, behaves very differently from your retirement accounts, behaves very differently from cars, business, bank accounts,
Whatever.
you name it.
Mhm.
Right. In lots of different ways, right? From a tax perspective, right?
Yes.
A cost basis adjustment happens to some of those assets and not to others. Some assets have beneficiary designations, right? Everyone knows about beneficiaries for life insurance policies, right? And for retirement accounts.
Mm-hmm.
Houses can, but generally don't have beneficiaries assigned to them, right?
Mhm.
Just like a business, we just talked about how a business works, very different from a house, or very different from your bank account, very different from your car, right? And so that's kind of one of the biggest arguments for working with an attorney to create an estate plan, is minimally they understand how the law interacts with your different assets.
And
Right.
there's an actual list of said assets. So
Yeah,
I think a lot of the
potentially.
time, So
Not
I think,
always.
well, or at least a better list,
Yeah,
right? So
yeah.
a lot of the time somebody dies and you don't even know what they have, right? So
Yeah.
if they've been to an estate attorney, at least we have a better idea of what they had, so we can deal with it properly.
Yeah, in theory.
In theory.
Yeah, that actually, you kind of goes back to your question of what are the biggest issues I see with estate
Mhm.
planning.
Yes.
That's actually one of the biggest issues of estate administration, probating a will or administering a trust, is people don't know where mom and dad's stuff is. People are like, I'm positive there's another bank account out there somewhere. Or we just found this other bank account that dad had 2 years after he died and we had no idea it was there. Or
So funny story.
I'm pretty sure there's a life insurance policy. We just can't find it.
So
that's actually a really big issue.
Yeah, so my grandmother died. And she didn't really have much, but she did have a bank account.
Mhm.
But she got Social Security benefits. And if she left too much money in that bank account, they would yank her Medicare.
Sure.
So she would have a friend of hers go pull cash out of the bank, right?
Mhm.
So when they're going through, when my dad and his brothers were going through all her stuff in her trailer in her house, they're like, there's got to be like a coffee can of cash somewhere. So they were like tearing the place apart looking for a coffee can of cash. They didn't find one, But it was just so interesting to be like, maybe there's a coffee can of cash somewhere, because she would totally, like, she would be the one that like, her. Would squirrel it away in a coffee can or stick it in a stuffed animal or something. Like, that's just how she was.
Yeah. And so that's kind of that struggle with estate planning is really a reflection of one of the issues I see with estate planning, right? Is there's a lack of financial information.
Yes.
Which goes back to, hopefully an attorney can work with the clients to help them understand how each of their different assets will behave in different situations according to what the law says and what their estate plan says. Right.
And to make it tax efficient.
Yep. And so in all of those things, really you're bringing in, I don't know, lots of times between a half a dozen and a dozen different types of assets, right? So I'm grouping all retirement accounts into one asset. Most people have more than one retirement account, and trying to get them to flow in the same direction and have them do the same thing. And that's just not something that's easy to do. One, two, lots of people don't know that they need to do that. And so they don't do it. And so there's a lot of internal inconsistencies within an estate plan, just if they do it on their own.
I love it.
So
that's why you hire the people.
I bought you as much time as I could.
That's why you hire the people. So specific about, so back to the values-based stuff.
Sure.
Can you give me just one specific example of how a client's values were incongruent with their estate plan and how you help them realign their plan?
Incongruent with their estate plan. That's a really good question. There's one that I was just going through just the other day. That's what it was. I was trying to remember what it was. Okay, so I kind of feel bad for this, actually. So they just signed their estate plan in early July. And I don't know why they were talking with an estate planning attorney in California, but they were talking with an estate planning in California. And they live up in Fort Collins, Larimer County. And she was like, I have a question about Colorado, this and that and the other, right? And so they wanted to give their son as much control as possible and protect it from outside creditors, right? Divorce, bankruptcy, lawsuits, stuff like that. Those are the two big ones. And I was looking through and I was like, not really, right? And so, because they gave him as much control as possible, but they were lacking with the protection. And that's a really tricky thing, is lots of times the more control you give
to one person, like it's a balance, right?
Yeah. So I call it, it's the seesaw effect. There's protection and access. If you take one up, the other one goes down, and vice versa. Right. But I was like, this is a decent job of the language that they had in here, but I was like, but there's a better way. Right. Because there's obviously not a trust issue. Confidence issue. I do that all the time. Not a revocable living trust issue. It's a confidence issue. Not a confidence issue in the son, but still wanting to protect. When you name, so there are a couple of different issues with this. Is one, she named the son as the administrator of the trust. We call that the trustee. So he's the trustee and the beneficiary. When you have your child be the trustee and the beneficiary, and there's like a lawsuit, then they can argue what's called the merger doctrine, where the trust and the child is merged, and they can argue that there's not really a legal difference between the two, which means it's 100% vulnerable to that lawsuit. And so I was like, okay, there's a better way to do this. What you can do is, because there's not a confidence issue, you keep him as trustee, but you bring in another trustee, and you can bifurcate their responsibilities. Well, you can do two things. You can have them be co-trustees, which means they have to come to agreement about every decision. And if there's a third person, you get protection because someone else can tell him no, which was lacking because there wasn't a third person. Or what I kind of like, and there's not really a difference between these two. You have they're co-trustees over everything, or you have him kind of be the administrative trustee. So he can step in and hire you to handle the tax accounting for the trust. He can be making investment decisions and, trustee reportings and just the day-to-day
admin stuff.
of the trust. But this third party, you give him the ability to hire and fire the third party, and that third party's job is only to handle distributions.
To approve the distributions.
Mm-hmm. Which, because there's not a confidence issue in him, that trustee kind of becomes a yes man. They say yes because they're supposed to say yes.
Yes, unless there's a reason to say no.
And if they say no, then they're fired because you give him the ability to do that. But you're okay with that. You just want it in the trust to protect it until they're supposed to say no. Until there's a lawsuit or until there's divorce, then they say no. And they're supposed to say
that's
no.
Their job.
Yep. And then the son goes back and says, hey, sorry, my trustee said no. I'm not allowed to force distributions out or anything like that. And then voila, there's protection. Right. And so they were close. They were half or 3/4 of the way there.
Not quite.
But that can blow up and become a much bigger issue than if you don't get there all the way. So that one's still kind of like a to be continued because that was only last week. But that's just sometimes it's have a lot of confidence, make it accessible, but have protection. Okay. Right. Which is a financial values expression, right? Don't know if that's what you were going for.
No, I think it is.
But close, but not as good as it could be.
Yeah. So they're saying, one of our values is protection around this.
Yep. The trust. And one of our values is you being able to access it and use it in your life as well.
So confidence in you, but also projection of the assets.
From the world around you.
Yeah, from the world around you.
Exactly.
So it just wasn't properly, those two values weren't properly taken care of at the same time.
Yep. They were.
Because they don't have to be incongruent. They can work together.
They can. Yep. So normally, like I said, it's normally the seesaw dynamic.
Yep. Makes sense.
But if you bring in this third party, you can finagle that a little bit, right? And they just didn't do all the finagling to get there.
I love it. It's just extra little things we don't think about.
Yep.
All right. So before I ask my last question, easiest way for people to find you?
Website.
All right. We'll link it. Way. We'll link it. We'll also link the other episodes Mr. Brandon has been in.
Sure. Yep. And on the website, on the bottom of all of the pages, there's a message me thing. So you can just fill out the information, write the message, and it goes to my email.
There's also a questionnaire about your trust deficiencies. I was going through that earlier today.
Oh, yeah.
Or your estate deficiencies.
So on the bottom of all those pages, of each of the main page and all the sub pages, there's a little green button. It says estate planning deficiencies checklist. It's really easy. It's, 15, 20 questions.
Yeah, it seems like a reasonable amount.
Yeah, it's not terrible.
It's not too many.
Yeah.
But it's also not like 2.
Yeah, we're dealing with life.
Maybe 10, 15 minutes of your time.
Yeah, something like that. And you just circle yes, no, or I don't know to each of those questions. And the idea is if you say no or I don't know to any of those questions, then you have a potential weakness. If you say yes, you're good.
Yeah.
Right? And
easy peasy.
Yep. And so that's just a self-assessment. And they're not too complicated.
No, it's not too complicated at all. I was going through it earlier when I was doing my questions because I hadn't seen that the last time I was there. I think it's newer on your website.
Well, the website's redesigned. It's probably easier to find this time.
Yeah, it's definitely easier to find because there was a green button.
So how did you, what emotions were you feeling when you
I didn't go through the questions.
You didn't go through the questions?
I was just kind of scanning them because I was like, what can I ask Brandon?
Okay. I thought you said that you were like answering.
No, I didn't answer.
Okay.
What is the top thing that could blow up an estate plan if not planned for?
The top thing that could blow up an estate plan if the estate plan's not planned for. Oh gosh. The first thing that came to my mind is that anything and everything.
All the things, Jamie.
All the things.
Everything.
No, the biggest thing is that could blow up an estate plan. Like if you don't have an estate plan at all, or if you have an estate plan but you didn't plan for.
The top thing that could blow up a not well-prepared probably well-prepared estate plan. Like what do we see? What thing or what event generally would blow up a boilerplate estate plan?
Yeah. So, man, I wish I knew that you were going to ask me that question. I would have had some good stats.
That's why it's the last question.
I know. But
it's to make you think all the things.
I know, but there's some really good stats that I don't know off the top of my head.
That's okay. We can always add them later.
But basically, there's this survey of people that they did of what are the biggest causes of loss of family wealth through the generations. And they've asked parents what they thought that was going to be, right? Or clients, right? What they thought that was going to be, and then what it actually was. And there's a big difference there, right? So I don't remember the numbers, but parents were most concerned about taxes and financial stuff like that. And I don't remember the percentage, but I want to say it's like 40% or 80%, just a very largest number by far is lack of communication and trust. It's the biggest thing that blows up an estate plan, because children don't know how much they're going to be getting until mom and dad are gone. And then all of a sudden mom and dad dying become a financial transaction, right? They're kind of blindsided of, hey, this is way more than I thought, or this is way less than I thought. They're not financially, it goes back to that lottery issue, right? And not all lottery winners are those $500 million lottery winners. There's a lot smaller ones too. People who, it's this, what is it called? The sudden wealth syndrome or something like that. People who are not adequately prepared.
Whatever,
something like that. People who are not prepared for a sudden influx of money that they haven't necessarily earned
or ever seen before.
And I mean that in a neutral term, not having earned, right? Whether that's inheritance or lottery,
we're not saying deserved.
We haven't worked for it.
Yeah, we're not saying deserved. We're saying
sudden money on our lap, just come in.
Didn't see it coming.
And they're not ready for it. They don't know how to plan and how to live their life of investing or this and that and the other. And so it's lack of communication and trust. Siblings don't communicate very well, especially if one's the trustee and the other ones aren't. People end up with different assets, right? So mom and dad's grandfather clock or their knickknacks. People lots of times fight over that stuff because those decisions weren't made beforehand.
And communicated.
Yeah. And so if anything, it's actually more the human element that can be planned for through purposeful planning.
What, right? Humans blow up?
Yeah. Right. Totally. Yeah. And so it's actually the human element that is, if you already have an estate plan, most estate plans reasonably do their job, right? Kind of what I said before, there's that survey, there's an 80% chance that an estate plan is going to be a burden. The money's getting there. The money getting there is not necessarily the problem. If it was, we would be sued for malpractice.
Right. It's what happens after.
It's what happens after. It's the impact that it's having. Money's a tool, right? Yeah. It's a neutral. It can be a positive impact or have a negative impact. And so people aren't thinking about what type of impact that money can have in people's lives, right? And
they're just worried about the transfer of assets.
They're worried about the transfer of assets, or they don't want their children to know how much they're worth. And so they don't talk about it. They don't talk about the plan, right? Even if you don't talk about the money, they're just like, oh, I'm not going to tell you anything about what you're getting. And so they find out when it's all over, when mom and dad are gone, there's no context, there's no explanation, there's no any of that. There's why did such and such get dad's wedding ring, or why did they get their stuffed animal collection or whatever.
It's so interesting.
And so it's actually more with existing estate plans. It's actually the human element, which is why the purposeful planning is important to me, because you're addressing that human element. Now, non-existing estate plans, what blows that up is actually life also, now that I think about it. And that is, if you don't have an estate plan, your state has an estate plan for you. There are default laws of where things go, right? If your goals are different from what the default law says, tough luck, right? So if you have a drug addict child, or you have a special needs child and you want them to be getting more than everybody else, or you needed to go into a special needs trust or anything like that. Or if you wanted to be spreading it out over time rather than one lump sum distribution, stuff like that can blow it up because it's not playing out how you wanted it to. Sometimes very much so, not just from an objective, individualized perspective, having a negative impact, but just straight up from an objective perspective. Like anyone could look at that and say, that's a bad idea. Yeah. Right. For whatever reason.
But
right?
just because you just get what you get.
Yeah. Because you didn't. Yeah, exactly. Because you didn't do any planning. There's nothing there. It's individualized. I personally don't have a problem with those laws. I think that the legislatures across the country do the best that they can.
Doing what they can.
Because it's state-based, right? As I say, across the country. They're doing the best they can, but they're trying to decide what do the majority of Coloradans, what would they want to have happen with this? Well, fine and dandy. But the thing is that people's estate plans are on an individual family level rather than the majority of the millions of people who live in Colorado level.
Yeah.
And it just lots of times just doesn't line up with what people would actually want to have happen.
So it's that communication piece.
Communication is the big one.
So it's really, I'm just going to go back to when my grandma died. She had said.
Is there a question after this?
No, there's no question. I'm done. I'm just going to tell a story and then we'll be done.
Okay.
My grandma had always, the only thing she said about her stuff was that I would get the hope chest. Jamie gets the hope chest. Jamie gets the hope chest.
Yep.
Jamie gets the hope chest. And I don't know why she picked me in that item, but that's the only thing she had communicated with anybody. So my dad called me. He's like, you get the hope chest. You got to come get it.
Okay.
Right?
Mm-hmm.
And so the brothers, because there's 3 of them, they basically just
your dad and aunts,
my dad
and uncles
and his 2 brothers.
Yep.
There's one older and one younger, if that matters. They just divvied out everything else. Mm-hmm. And one of my cousins got a ring that I would have liked to have, but then I got their wedding ring, my grandma's wedding ring. So I was like,
can't complain too.
Yeah, well, I'm not going to complain because it wasn't my job.
Sure.
Like if I had done it, I would have gotten what I wanted, right?
Mm-hmm.
But it wasn't in anybody's job but the boys to do it, and they did it in cooperation, and they basically just handled it, which is rare. She didn't have a whole lot of assets, so I think that's part of it, and the other part of it is the boys just went through and just
decided on their own.
Just decided, which I think rarely happens in such a congenial way.
Yeah.
I mean, there wasn't much.
It just depends on how much people care.
Yeah.
About that stuff.
Yeah. And they don't.
Yeah.
Like they both, all 3 of them are just kind of like, whatever, I'll take what I can get, or, I'll take, maybe this thing is more important to you and that's fine and whatever.
Yep.
So they actually had the ability to do that. But in any other time anybody else has died in my family, I've never seen something congenial happen that quick. Like they literally did it in 3 days and they're just like,
done. Yep.
Stuff, bank account, and done.
Mm-hmm.
But most of us don't have that little stuff, though, also.
Yeah. So
I think she had like a bank account and her stuff,
Yeah. Mm-hmm. And then, so an opposite example of that is, so my parents-in-law, they went to China for a year to teach English at university. And before they left, my father-in-law sent an email out to all of his kids, all 6 of them, and said, hey, just in case something happens, what of our stuff do people want? So he actually, and this is part of a normal estate plan, but this was an impetus for him to actually do it. He said, okay, this is all the list of all of our stuff that I can think of. Say what you want. And if there's something in here that's something that's not in here that you're interested, put it in, right? And so he actually went through and people decided what it was that they wanted, right? He did that with his books and all that stuff. And if there were conflicts, if more than one person wanted something, they would kind of talk it through and make decisions and stuff like that. And then he went around and put it into his estate plan. And that's a way to encourage the congeniality, because it's planning, it's proactive rather than, as positive as it was for your family, that's still reactive.
Yeah.
Right. But this is proactive. People have already said what they're interested in. It's
not emotionally
it's codified
charged,
in the estate plan,
it's
right?
not emotionally charged.
People are talking about it when they're happy, right? And so that's, it's just good planning.
Yeah.
Good planning prevents bad things. Well, lots of times.
I love that. But then it also lets everybody know what everybody's getting and lets everybody say, hey, that thing is really kind of important to me. And the parents maybe didn't know that. Yeah. Right?
Yep. Also for us, Emily really wants my parents' piano, or her parents' piano. She literally did not check any other box of anything else. She was like, I just really want to make sure that they understand that is all that I would want, is the piano. I was like, your parents have some really nice paintings that I like. What about those? It's like, if you had to choose, and I was like, okay, fine. Like, it's just piano, right? And so that's just what she really cared about.
That's what has meaning and value to her.
Yeah, that's a value expression, right? It's, I really want the piano. And so that's the only thing we're getting, but she and we are happy with that, because that's the one thing that we most wanted. And we're able to figure that out now, rather than after they're gone. People are grieving. People are, they're missing mom and dad.
Feelings.
Yep. Yeah. You're missing that mediator, right? That is parents and stuff like that. And so it makes it a lot easier when you do things when people are happy and alive.
I love it. We're going to end there.
Yeah, happy and alive. Great.
Thank you so much.
My pleasure.
It's a lot of talking, Brandon.
Sorry.
No, it's awesome.
What time is it?
11:30.
Okay, I gotta go.
I know you do.
I'm gonna be late.
Hey y'all, thanks for listening. If you found this podcast to be inspiring, helpful, and entertaining, please like and subscribe. This helps us grow the community and reach more people. If you are interested in learning more about this episode's guest or accessing any of the books or other resources mentioned in this episode, be sure to check out the description box below. Until next time, be abundant.